Welcome to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Hi, Joe.
Hi, Pam. Pam, today we're going to talk about immigration and asylum. And, you know, I did an asylum case once. You probably didn't know that about me.
I did not know that.
And thank God we won. But it was really a difficult emotional experience for me because you might believe in closed borders, and I suppose I do. That is, I'm not for completely open borders. And you might think if you have closed borders and you don't let anyone come in for economic reasons, and you have an asylum provision, you better police that pretty tightly. And you might think then you need jails and the equivalent of border guards and the like. But when you see someone in front of you whose only crime at worst is really going through hell to get in this country, and you think of how much they've traveled, it's hard not to think you'd want them for your neighbor. And seeing scores of these people, knowing that most were going to be deported and were going to lose, it was emotionally difficult.
Yeah, I mean, I always think back to there's a famous speech that Franklin Roosevelt gave at the Daughters of the American Revolution, which, you know, is this kind of, in some ways, hoity-toity group of people who can trace their roots back to the people who were here during the Revolution. And he began the speech by saying, "Hello, fellow immigrants." And I think it's true for almost everybody in the United States that at least some of their ancestors were immigrants to this country after this country got started. And so there is that sense of, you know, who am I to criticize other people for wanting to come to the United States and make their lives and make their lives better. And today we have with us one of our recent law school grads, somebody we're just so incredibly proud to call a Stanford Law School alumna, Katrina Eiland, who has been a public interest lawyer from the time she left here and is currently a staff lawyer at the Immigrants' Rights Project of the American Civil Liberties Union. But she comes to this with just a huge wealth of experience representing people who are in the country without documentation, representing people who want to come into the country, both in immigration-related jobs and in employment and like. So we're just incredibly happy to have you back here with us, Katrina. So welcome to the show.
Thank you so much for having me.
So, Joe, I know you wanted to talk to Katrina a little bit about asylum because that's one of the things that you spend a lot of your time doing in your litigation now.
That's right. And, you know, I was struck, Katrina, by a blog you wrote. And I think that if our listeners will just Google your name, they're going to find this blog. So maybe I'll just make it that simple.
But we should say, although Katrina Eiland, it's not Island like Long Island or, you know, those. It's Eiland for those of you who want to check her out.
Yeah, it's a little spelling test for people out there. Thank you, Pam. It was a really affecting blog, from emotionally affecting. It's about a woman named Grace. And so can you just tell us what happened to Grace? What's Grace's story?
So Grace is one of the named plaintiffs in our lawsuit, Grace v. Sessions, which is challenging the ratcheting up of the standard for individuals to be able to get to a full asylum hearing, the credible fear interview. And she's a woman who came from Central America in a long, treacherous journey to escape decades of sexual violence, domestic violence at the hands of a partner. And the government, whose help she sought several times, was unable and unwilling to protect her from that brutal violence. And she fled to the United States after a particularly egregious incident and sought protection here.
And the standard is what? Or at least what has the standard been for someone who might fall into, I don't know, a battered woman category where you're in a location where you're being abused and nobody's going to help you? What was the standard 2 years ago, 4 years ago, if you describe it?
So the standard has always been very case-specific and dependent on the facts and circumstances of the case. But essentially, if you can show that you've been persecuted or that there's a probability that you'd be persecuted based on a protected category, and one of those protected categories is a particular social group. And for decades, gender-based violence and various categories of gender-based violence have fallen within that particular social group category, including women who had experienced domestic violence.
So Grace comes here. She seems to be part of this protected social group, and we have a statute that said you can get asylum if that's the case. What happens? What's new?
So unfortunately, Grace arrived shortly after new credible fear screening procedures went into effect. And those caused a plummeting in individuals passing the credible fear interview, which is the threshold process to be able to seek asylum.
So this is an interview with somebody from the immigration authorities who interviews you and asks you questions to determine, are you coming here because you've been persecuted as a victim of domestic violence or as a political dissident or because you're a member of a religious minority, right?
That's correct. It's from the Asylum Office of the United States Citizenship and Immigration Services, and it's an interview that's supposed to present a low threshold screening because Congress intended to make sure that anyone who had a possibly legitimate claim for asylum wouldn't be summarily removed back to violence or death.
And this is just the first step in ultimately getting asylum, right? This is like the initial interview, and then you have to show a lot more actually to get to stay at the end of the day.
That's correct. It's only the first step, and after that, if you are found to have a credible fear of persecution, then you're placed in what's called removal proceedings, the sort of normal removal proceedings, where you have all the procedural protections that immigration court provides, and you have time to find a lawyer, and you're able to present your full asylum case.
Thank you. So Grace comes, and she's got some evidence that if she goes back, she's going to be abused again. Why doesn't she pass the credible fear test?
Well, one of the problems is that in the new credible fear policies, Attorney General Sessions and then the Asylum Office basically made a new pronouncement that generally, under the standard, individuals who had domestic violence or gang-related claims for asylum generally would not pass this credible fear screening. And that is a broad, sweeping statement that is just incorrect under the law.
Did they give some explanation for why they were doing that, or did they just announce it?
Well, there was a very fact-specific case in which this pronouncement was made, and there were some narrow holdings by the Attorney General as to specific issues in that case. But it's sort of inexplicable why the Attorney General went from these specific facts and made a jump all the way to, none of these claims are likely to pass in credible fear, which is a different standard than the full asylum
Because
proceeding.
The plain meaning of credible fear would be fact-specific. Is your fear credible? But now there's a presumption that if you're coming here to escape domestic violence or gang violence, it's not credible.
Well, it's a little bit different than that. The word credible is a little bit confusing because it doesn't have anything to do with the credible nature of the claim. So all of our clients in the Grace case were found to be credible in that they believed that they were telling the truth, but they found that they couldn't satisfy this threshold screening standard, that they had a significant possibility of being able to ultimately get asylum.
This is Stanford Legal, and today we're talking with Katrina Eiland, a Stanford graduate and a staff lawyer at the Immigrants' Rights Project, about asylum. And so I just want to kind of drill down just a tiny little bit on what you were just saying to Joe. So it's the government believes that they will, in fact, face gang violence or domestic violence if they go home, but the government is saying, we just don't care.
That's essentially correct. That they're saying under these pronouncements, we don't think you satisfy this standard. You don't fit into this particular.
You're not
box.
a special. You're not a social group anymore.
Right, and that's another problem with these new policies because when folks are coming to the border, they've gone on a long, treacherous journey. They're frequently traumatized, having just suffered horrific violence, and they have these interviews shortly after arriving. And so it's always been that you don't have an obligation to define the particular social group that you fall into because that should happen later when you have more time and resources and can get documentation. And one of the problems here is that the Asylum Office was essentially putting out guidance saying that that individuals need to define their particular social group at that stage.
And just to let our listeners know, particular social group comes from a statute that says you can get asylum if you're coming here because of persecution that's political or racial or religious, or as a member of a particular social group. And Grace's social group would be abused women, something like that, victims of domestic violence. That seems like that's been kind of read out of the statute. I want to ask you a related question that we've talked about, which is on these kinds of cases. Does it matter if you're being oppressed by the government or not? As I understand it, in the past, as long as you were oppressed and the government didn't help you, you could come here. What's the new standard that's been articulated?
That's right. It's supposed to equally apply, the asylum protections equally apply to people who are persecuted by non-governmental actors. And the rule has always been that as long as your government was unwilling or unable to protect you from that persecution, that you could qualify for asylum. And now, in these new credible fear policies, they've ratcheted up that standard to say that the government now has to be completely helpless or even go so far as to condone the persecution against you.
And this isn't the only problem that we're facing with asylum today. I mean, you've explained to us a bunch of other problems as well, and I wonder if you might turn to one of those and sort of give us a sense of where asylum is moving in this country, where one of our most famous images is the Statue of Liberty with, give us your tired, your poor, your huddled masses yearning to be free. And now it's like, keep out of here, huddled masses yearning to be free.
Yeah, so the Grace situation, the credible fear policies are just one of many attacks on the asylum system. Right now, there's also President Trump has attempted to make it so that any individual who crosses into the United States in between a port of entry, so doesn't go to an official site where you can enter, across the southern border and present yourself, that anyone who comes in apart from one of those ports of entry cannot apply for asylum.
So the asylum laws say you can apply for asylum as long as you have a credible fear, but he's saying that you have to show up at one of the border stations first. That if you're already in the country, you can't apply for asylum.
That's right. And if you don't, present yourself, then you're ineligible for asylum, despite the fact that the statute, the law that has been on the books since the Refugee Act of 1980, says that anyone can apply for asylum regardless of how you entered.
This is Stanford Legal, and today we're talking with Katrina Eiland, a staff attorney at the Immigrants' Rights Project, about asylum and immigration. Joe?
I want to pick up on this new position of the Trump administration. Now, a lot of people might say, first of all, well, it makes sense you should go to the official place and not just any place. So why don't everyone just go to the official port of entry and apply there?
Well, there are a couple of problems with that. First, that's not what our laws have always been. And part of the reason for that is our obligations under international treaties, that it doesn't matter the manner of entry. Frequently, people are fleeing violence, and it's very difficult for them to be able to plan their plan in advance how they're going to seek asylum. And the other problem with that is that the Trump administration is also making it very difficult to apply for asylum at those port of entries. So they're trying to...
Well, they shut down the one in Southern California for quite a while, didn't they?
That's right. And so it's sort of putting asylum seekers in an impossible position where if they enter without going to a port of entry, they're not eligible. And if they try, they may be waiting at a port of entry for weeks and weeks.
Which is a real problem. And then even once they get into the country, we're now seeing problems with people who have gone to a port of entry and come into the country. It used to be that they got what was called paroled. That is, while their case was pending, they could live free in the United States. And now that's not happening. We've seen a lot of that, particularly with the family separation stuff. Could you talk a little bit about that?
Yeah, that's right. So the parole used to be, routinely granted when someone passed a credible fear interview. While they were awaiting their asylum proceeding, they'd be released, sometimes on conditions to wear an ankle monitor. And now that's not happening. It's happening at very low rates. We have a client who was just recently released after 2 years of detention. He had his asylum claim granted twice, but the government continued to appeal. And during that time, they refused to release him, even though he had a sponsor waiting for him, saying, we'd be happy to have you come live with us and make sure you go to your hearings. And that's, very connected to the problem of family separations. That's kind of a third way that the administration is really deterring people from seeking asylum, saying if you come to the border with your child, we're going to separate you and detain you in separate places, and you have no idea when you might see your child again.
And in the past, you'd be paroled, so this wouldn't be an issue. Is that right?
Yeah, in many cases, if the parent was paroled, they would be out of custody and then be able to be reunited with their child and await their asylum hearing together.
And it sounded to me from some of the stuff I've read as if the government was trying to use this separation as a way to get people to give up their asylum claims. That is, if you want to see your child again, give up your asylum claim and we'll send you and the child back to wherever you came from. Is that still happening?
Well, due to an injunction in the case, that was certainly happening, but due to an injunction in the case over the summer, the government was forced to reunite about 2,500 children with their parents that had been separated over a long process that's been really difficult. But it was thousands of children.
Well, and one of the things that it was striking to me is the people from the ACLU were representing a lot of those parent-child combinations. And one of the things that was amazing is at some point the government said, well, yeah, we have hundreds of these children. We don't know who their parents are. We don't know where they are. ACLU, you go and find them, which struck me as, an odd thing for the government to say.
That's right. And they had data that they produced, to try to match up the parents and kids. But there were some parents who had already been deported that the government, frankly, didn't know how to reunite them. And there were a couple of ACLU attorneys that went to Central America to actually try to look for these parents.
When the government reunited the parents and the kids, how did they do it? Did they leave the parents in prison? And because I guess we can call it's prison-like. I mean, as you're waiting for your hearings, you have really less rights and are treated worse than you would if you committed many crimes, I think. Did they give them parole at that point?
It's a complicated question, and it happened in a lot of different ways. And part of the complication is that children are usually under the custody of a separate entity under the Health and Human Services, and the parents are in ICE custody, which is sort of another complicating factor for figuring out how to get the parents and kids back together, and one of the reasons why it was a really difficult process, despite the ease with which they were separated in the first place.
Well, we'll be back with more from our guest, Katrina Eiland, talking about asylum and immigration next on Stanford Legal here on Sirius XM Insight 121. Welcome back to Stanford Legal, where we look at the cases, questions, conflicts, and legal stories that affect us all every day. I'm Pam Carlin, along with Joe Bankman. Joe?
Katrina, a minute ago, we were talking about asylum. I want to change this subject to something related, which is DACA. This is a deferred action for childhood arrivals. Bring us up to date on what's happening there.
So the program started in June of 2012. The Department of Homeland Security announced that young immigrants who came here as children and who met certain educational residency criteria and didn't have certain criminal history would be eligible to apply, get Social Security numbers, get a work permit, access driver's license, education. The program's been wildly successful. But as you know, it came under attack last year when the government rescinded the program in September of 2017.
Well, it kind of tried to rescind the program, right?
Exactly. So, in September 2017, the administration announced that it was going to be winding down the program over the next 6 months. But during that 6-month period, several actions were filed challenging the termination of the program. And in the course of those cases, judges issued injunctions blocking the end of the program, sort of preventing the government from taking the program away.
And I imagine the administration is challenging all those injunctions and sooner or later the Supreme Court's going to decide it.
That's right. So actually, it was appealed here in the Ninth Circuit, and there was oral argument on it in May. And for a long time, everyone was sort of waiting to see what would happen. And the administration said, well, if you don't decide this quickly, we're going to leapfrog you and go directly to the Supreme Court and ask for the Supreme Court to grant cert, even though the appeals court hasn't even considered it. And they made good on their threat. They filed that application with the Supreme Court, and a few days later, the Ninth Circuit ruled and upheld the injunction, keeping the program in place. So for now, the government is continuing to accept applications, process applications from individuals who already had DACA.
So how many people are we talking about?
Around the time that the program was rescinded, it was about 650,000 young immigrants. It's been, at various times close to 800,000, but it's a very large number of young people.
And these are people, some of them arrived in the country as babies. This is the only country they've really ever known.
That's right. I think, many of them don't speak the languages in their home countries. They've been educated in our schools. They're in a variety of professions. There's been a lot of research done on exactly the profile of who these DACA recipients are. And they're people who work in our healthcare systems, they're teachers, they're construction workers, and they're contributing to our communities and economy.
And students at Stanford.
That's right.
Yeah, I had a student in my class last year who was a DACA student. And I think the kind of fear that they have, because, of course, in order to get into DACA, you had to provide the government with a lot of information that otherwise the government might not have about where you lived, what you do, fingerprints, and the like. And so the question of if the government gets rid of DACA, will it use all of the things you gave the government as a way of kind of finding you and removing you from the country and indeed sending you to a place you may have been only for a month as a small child or 6 months as a small child? That's a real threat.
And Katrina, you're not yourself litigating the big DACA picture. You're litigating a smaller issue that is relevant for hundreds and hundreds of recipients of DACA right now.
That's right. In addition to the sort of uncertainty around whether the program will continue, how much longer it will be in effect if the Supreme Court chooses to hear the case, there's also the issue of individual DACA recipients having their DACA terminated arbitrarily and without any kind of notice. And that has been happening more and more under the Trump administration. Hundreds of young people sort of woke up one day and were told they didn't have DACA anymore. And so we are litigating a case challenging the government's ability to do that and trying to enforce the rules that they put in place for the DACA program, which we believe requires that kind of basic process. So someone can say, hey, I think you have mistaken information, or I'm not sure what this is about.
So someone gets arrested for the wrong thing and gets mistaken for a felon, or someone that's arrested for a felony, and then they're immediately, in effect, deported, or the deportation proceedings immediately begin.
Well, the DACA and the deportation proceedings are separate, but it's really it sort of upends someone's life who has got a job and a driver's license and maybe going to school to have their future really uncertain, to not know what's going to happen to them.
This is Stanford Legal, and today we're talking with Katrina Eiland, a staff lawyer at the Immigrants' Rights Project, about immigration and asylum. And a couple of times recently you've mentioned that you've gone into court, and you're going into federal courts with judges who have life tenure, who are independent of the executive branch, and so therefore face no real consequence from ruling against the government. And they've been repeatedly ruling against the government and in favor of your clients. But most immigration cases are not decided, or at least not originally decided, by these federal courts with independent judges. They're decided through a series of immigration courts. And I think this is something a lot of our listeners probably don't know anything about. So could you talk a little bit about that?
Sure. So as you mentioned, the immigration courts are different. They're actually within the Department of Justice. So the Department of Justice is where the Attorney General sits. The Attorney General is the sort of head prosecutor for immigration cases.
So he appoints the judges for the cases he's kind of quote unquote prosecuting.
Precisely. And so all of the judges that are within the immigration courts are actually employees of the Department of Justice. They're not independent judges. They have civil service protections, but other than that, it's nothing like the life tenure that Article 3 federal judges have.
And recently, the Attorney General's office has changed some of the rules for dealing with those judges. Could you talk a little bit about that?
Yeah, so the Attorney General has really sort of put the pressure on immigration courts to sort of speed through their cases. They've imposed quotas on judges for how many cases per year they need to get through. And in addition, the Attorney General's also done what's called certified cases to himself, where he can basically take cases away from the Board of Immigration Appeals, which is supposed to sort of be the appellate body for immigration cases, and decide them himself. And so he's done that to try to change the way immigration courts work, to say, I'm going to take your discretion away, immigration judges, from being able to continue a case or from being able to close a case because it doesn't make sense to move forward right now.
By continue a case, you mean kind of postpone deciding it, keep the case alive while you wait for more evidence to come in or for briefs or the like. And why is it that speeding up the cases is particularly bad for people who are seeking to stay?
So in many cases, as you said, they might need more time to find a lawyer. They might need time to get evidence for their case. There might be a petition that they have pending to get legal status. So at the time, it doesn't make sense to push forward and have their removal proceedings go ahead if, a couple months from now, they might have a petition approved that's going to allow them to stay lawfully. So a lot of it is about, sometimes these ability to pause cases actually makes things more efficient. But the Attorney General wants to take that discretion away from these immigration judges, and they're already sort of compromised because they're within the Department of Justice to begin with, and they're sort of making it so there's immigrants have a tougher time getting a fair shake in their proceedings.
I wonder why, in the long run, you'd ever expect to get a shake different than the Attorney General wants you to get. It seems at the extreme, if this is someone who's going to take individual cases himself, if you as a judge disagree with them, then the court is effectively the Attorney General.
Yeah, and that's highly problematic to have the sort of judge be the prosecutor. It's a really concerning state of affairs where, really we want independent judges to make decisions in often life-threatening situations. There's an immigration judge who likens, immigration court to sort of making death penalty decisions in a traffic court setting.
Where do you think we're going with this in the next year or so? You've outlined a lot of Trump administration initiatives that are pointing in one direction, clearly to restrict immigration, make it harder. Are there new things coming down the pike? Do you think you're going to be successful in maintaining an equilibrium here?
We're doing our best to challenge the policies that we think are unlawful, and as been mentioned, we've been successful in some cases, but the government has definitely been aggressively fighting to keep these policies in place and has appealed, most of the decisions. In fact, the asylum ban that we mentioned earlier, they made an emergency stay request to the Ninth Circuit, which was denied, and then just then went to the Supreme Court right after that. So, there's definitely an aggressive moves to keep these policies in place, and I'm sure we'll see more sort of the same kind in the next couple of years.
Well, and we'll be looking to see what happens and hope to have you back in a later show to bring us up to speed on what's happened since then. So thanks so much for joining us, Katrina, and thanks to our listeners for joining us on Stanford Legal here on Sirius XM Insight 121.